Thank you for visiting my channel. Before we start, please hit the subscribe button so you'll be notified of future presentations. Today, we discuss briefly the legal concept of Res Ipsa Loquitur, which translates to "the thing speaks for itself." Res ipsa loquitur is a legal doctrine that allows a plaintiff to establish a presumption of negligence on the part of the defendant without having to present direct evidence of the defendant's breach of duty. The phrase res ipsa loquitur is Latin for "the thing speaks for itself." The doctrine of res ipsa loquitur is based on the idea that certain types of accidents or injuries would not occur in the absence of negligence. When the plaintiff is able to demonstrate that the accident or injury would not have occurred but for the defendant's negligence, the burden shifts to the defendant to prove that they were not negligent. Res ipsa loquitur is used in cases where the cause of an accident or injury is not immediately apparent or where the plaintiff lacks direct evidence of the defendant's negligence. For example, if a patient undergoes surgery and a surgical instrument is left inside the patient's body, the doctrine of res ipsa loquitur may be used to establish a presumption of negligence on the part of the surgeon or hospital. The application of res ipsa loquitur varies by jurisdiction, but in general, the plaintiff must establish three elements to invoke the doctrine. 1. The injury or accident was of a type that does not ordinarily occur in the absence of negligence. 2. The injury or accident was caused by an instrumentality or condition that was under the defendant's control. And 3. The plaintiff did not contribute to the injury or accident. One case where the doctrine of res ipsa loquitur was applied is the case of Africa versus Caltex Philippines Incorporated. In that case, Caltex was held liable for the damage done to the property of its neighbors when fire broke out in a Caltex service station while gasoline from a tank truck was being unloaded into an underground storage tank. The fire spread to and burned the neighboring houses. The principle applies because the gas station, with all its appliances, equipment, and employees, was under the control of the defendant. The persons who knew or could have known how the fire started were the defendant and its employees, but they gave no explanation whatsoever. It is a fair and reasonable inference that the incident happened because of want of care. In summary, the doctrine of res ipsa loquitur allows a plaintiff to establish a presumption of negligence on the part of the defendant in cases where direct evidence of negligence is lacking, based on the principle that certain types of accidents or injuries would not occur in the absence of negligence. If you find this presentation helpful, please hit the subscribe button to receive notification of future presentations. Thank you.